Welcome to this video on a pivotal case before the Ysleta del Sur Pueblo Appeals Court, Pueblo Gaming Commission versus El Paso Ventures, LLC. The core legal question revolves around determining the scope of inherent tribal sovereignty and regulatory authority over third-party vendors on Pueblo trust lands. This video will cover three main areas. First, tribal sovereignty, analyzing the inherent rights of native nations to govern their lands. Second, commercial regulation, focusing on authority over third-party vendors. And third, jurisdictional analysis, evaluating conflicts between different legal frameworks. In summary, this case is a vendor licensing dispute between the Pueblo Gaming Commission and a non-tribal logistics contractor. The heart of the matter concerns who has the final say on commercial conduct within Pueblo territory. The appellant is the Pueblo Gaming Commission, the regulatory body overseeing tribal gaming and commercial activity. The respondent is El Paso Ventures, LLC, a non-tribal logistics firm providing specialized equipment to the Speaking Rock Entertainment Center. The Ysleta del Sur Pueblo is a federally recognized sovereign tribe, restored to federal status under the 1987 Restoration Act. The Speaking Rock Entertainment Center serves as a vital economic engine for Pueblo's self-sufficiency. The dispute centers on the Pueblo's 2022 directive, which mandates comprehensive background checks and strict licensing requirements for all third-party vendors. The Pueblo asserts this as an exercise of its inherent sovereignty to regulate commercial activity on trust lands. El Paso Ventures, LLC, as a logistics provider, explicitly refused to comply with the 2022 licensing directive. This refusal acted as the catalyst for the legal conflict, challenging the Pueblo's regulatory authority over non-tribal entities. The lower tribal court initially ruled for El Paso Ventures. It held that the directive exceeded Pueblo regulatory authority granted under the Restoration Act and, applying the Montana versus United States test, concluded the Pueblo lacked jurisdiction over non-tribal entities. The appeals court is examining two main issues. First, statutory interpretation. Does the Restoration Act grant the Commission inherent authority to regulate third-party vendors? Second, the Montana standard. Did the lower court misapply the legal test for tribal jurisdiction over non-tribal entities on trust lands? The Pueblo Gaming Commission argues that the tribal court misinterpreted the Restoration Act, narrowly confining regulatory authority to bingo operations. They contend the court tenured the Pueblo's inherent sovereignty to manage the marketplace on its own trust lands. The Pueblo's sovereignty argument centers on regulation being a core sovereign function necessary for marketplace integrity. They argue that tribal authority is not narrowly limited to gaming, but extends to all commercial activities affecting the community. The Pueblo contends the lower court misapplied the Montana rule by failing to recognize the consensual relationship exception. They argue that EPV voluntarily entered a commercial relationship, thus submitting to tribal regulatory authority. The consensual relationship exception applies when non-members establish ties with the tribe through contracts or commercial dealings. Sustained economic involvement on trust lands justifies tribal oversight to protect the community and marketplace. The Pueblo also invokes the health and welfare exception. Unvetted vendors may compromise gaming integrity, economic security, and public safety. The Pueblo retains inherent authority to mitigate these risks for the community's welfare. The appellant's theory, sovereign regulatory authority, asserts that the Pueblo must regulate its economy as an act of inherent sovereignty. The respondent's theory, limited delegation, argues the Restoration Act restricts Pueblo authority to a narrow regulatory scope. El Paso Ventures contends that the Restoration Act only permits regulation of gaming, precluding authority over non-gaming commercial activities. They argue that the vendor directive represents a clear regulatory overreach outside the scope of federal statutory law. The core of El Paso Ventures' argument is that the Restoration Act limits the Pueblo's regulatory authority to the specific gaming authorized, not external vendors. They assert that the act does not create blanket jurisdiction over every commercial interaction. Regarding the Montana test, El Paso Ventures argues that the licensing requirement is not necessary to protect tribal self-government. They claim their logistical services do not pose direct threats to the Pueblo's political integrity or health and welfare. El Paso Ventures disputes the application of the consensual relationship exception, asserting that their basic commercial contract for logistics does not constitute a consent to comprehensive, non-gaming tribal regulation.